Welcome, everyone. Very nice, Jason. Thank you for that. We are kicking off our third season, not our third year, our third season, we're calling it, of the Conversation series. So this is the season premiere, I guess, if we're keeping with that metaphor. Great to see you all. I'm Ben Matier. I know most of you, and I want to thank you for coming here today. I know that we're going to have a very thought-provoking discussion, so I'm very excited about that. We have an excellent program planned for this year. We have a couple other events this fall. That beautiful poster, Andrea and Brittany did a lot of work putting all this together, so thank them. We have a branded series in the spring in the Life Science Ethics program focused on conservation biology, biodiversity. So we're really hoping to see you all every month over the next year. Just to remind you, the goal of the series is to present a big problem or a big question of interest in a particular field of research that appeals beyond that field. And the idea is to look at that question from the point of view, I think, of a discipline, but then expand the discussion. And to quote the promotional material, having scholars from different disciplines engage with each other to discuss a contemporary issue is very exciting. So don't let us down. Don't let us down.
Be excited.
I think we're all very excited about today. And so let me introduce Jane and Carolina, and then I'm going to turn it over to them. They have a presentation and discussion for about half an hour or so, and then things will open up. Most of you know Jane Maienschein, the director of the Center of Biology and Society, specializes in the history and philosophy of biology and the way that biology, bioethics, and biopolicy play out in society. I think many of you also know that Jane has received just about every award possible at ASU. And some impossible ones. I was thinking of John Legend this week, the singer, right? Is now an EGOT, right? So he's won an Emmy, a Grammy, an Oscar, and a Tony, right? So there's the Jane, and Jane has the Jane, the full Jane. Most recently, in 2015, she was awarded the exclusive University Professor Award. So very, very impressive. Carolina Abboud is a PhD student in biology and society. She received her undergraduate degree in the program as well in 2016. She's interested in how language plays into the explanation of science to the public and how this process shapes the perception of science. Her dissertation looks at the rhetoric surrounding embryos and fetuses in 20th century court documents, scientific papers, and popular written works. And I suspect we're going to hear more about some of this here today. So please join me in welcoming Jane and Carolina.
And Carolina just is part of the grad student team that won the History of Science Society Hazen Education Prize for the Embryo Project. So yay, yay. So what we're going to do, Carolina and I don't like PowerPoint for all purposes, so I'm going to lay out some kind of like the glossary, background concepts, and then I will talk about a couple of court cases, and then Carolina will talk about a couple, and then we'll open for discussion. The big question that we're thinking about is, what are embryos? How do we understand them? And in particular, what do different court cases show about both how we understand them and then also how the court cases influence the understanding? So the science that goes into court cases and then what the court cases influence as well. Okay, so embryos. So thank all of you ecosystems people for coming. We're not going to talk about embryo environment, but I suppose we could in some way and try to make it count. But no. So what are embryos, and what is the term that we're talking about? So let me just show you the basics. We're going to write on the board. I'm going to write on the board. Okay, in the beginning is an egg that gets fertilized. All right, so that's usually thought to be the beginning of the organism. All right, but in fact, when we're counting time, what's important, and important in law and biology and medicine, is the LMP, which shows up in law, there are lots of letters. the last menstrual period. So in fact, time is measured from that point because that's what we know, and not from this point, which is invisible. Okay, so then what happens, the embryo up for sort of 5 to 4, no more than 14 days, then becomes implanted in the uterus. Sorry, it didn't get smaller, I just drew it smaller. But so it gets implanted in the uterus, and in some legal discussions, this stage is called the pre-embryo or pre-implantation embryo. President George W. Bush referred to pre-embryo and made that distinction. So at implantation, something happens that is different. And then it's called an embryo up until week, so this is embryo, up until week, and I'm sorry that I write so sloppy, but you know what I mean. So 8 weeks or 10 weeks, where 10 is measuring from here and 8 is measuring from here. And so it used to be in biology, it was 8 because biologically this is what matters, but in medical and legal discussion, it's 10 because there's that. And then it's called a fetus. And so what's the distinction? What happens here? The embryo here is embryonic, and its structure is embryonic, meaning that it's not fully formed. By this point, it's still not fully formed, but it has the rudimentary form of all of the organ systems. So it becomes a fetus at the point it has that rudimentary form. It does not have function yet. It does not feel pain, have pain receptors, things like that, other functions, but it has the rudimentary form. So that's why there's a distinction at that point. And that distinction has been made back to the 17th century, and held pretty firm. And then it's called a fetus until it's born, and then it's called a baby. So this isn't a baby, and this isn't a baby in legal and medical and biological terms, though conceptually for people, the social feeling is that's my baby for some people. And so it gets very messy, and the courts have to deal with the fact that they're biological and medical terms as well as social terms, and people think and mean different things. At the 20-week period, it's still a fetus, but at the 20-week period in law and for the CDC and other agencies, there's a distinction that if this fetus dies at that point, it's called a stillbirth, and that has legal meaning. And this fetus has a certain different legal standing in most states. Some states make that at the 24-week period, which is thought to be viability, or 23 weeks or 22 weeks. But increasingly, 20 is taken as the earliest possible time that you have something that has enough functioning that it could possibly live if we had a whole lot more technology than we have now. Before 20 weeks, not possible with anything we can conceptualize now, which doesn't mean in another century that wouldn't change. But so 20 weeks in law in liberal states like Massachusetts and conservative states, 20 weeks is recognized as something different. Before that time, if this dies, it's called a miscarriage. And we say that word, and Carolina and I suddenly realized, talking about this, we say that word, oh yeah, miscarriage, yeah, that's a standard thing, we know what that is, the embryo or fetus died. Wait, it's called a miscarriage. The mother, the woman somehow did something wrong. I mean, there's something wrong with that term. That woman did something wrong, and her carriage of that embryo or fetus went astray and was wrong. So it's worth thinking about the history of that term. Okay, so that's kind of the landscape that we're going to talk about. I'm going to mention two cases, one in Arizona and one a federal case that I was involved with. So this is me in the courts. Carolina's going to then step back and look at those cases, well, look at other cases that have been important a bit more, as well as I think talk about one of the cases that I'm going to mention. So the state of Arizona case in 2005 that I want to mention is called Jeter v. Mayo. So it was a case where Mr. and Mrs. Jeter, who called themselves that, so I'm not saying it's Mr. and Mrs., but Mr. and Mrs. Jeter filed a lawsuit against Mayo Clinic because Mayo lost, misplaced, failed to deliver from Mayo Clinic to another clinic the embryos that the Jeters had caused to be fertilized in the IVF clinic. So Jeters had gone to Mayo to get eggs fertilized to produce embryos, and they wanted to have those implanted in a successful pregnancy. They did not succeed, and they then decided they didn't like Mayo, so they wanted to get those embryos moved to another clinic. Somewhere between Mayo and that other clinic, some of the embryos got lost. So the Jeters filed a wrongful death suit. They played with various ideas of murder and other manslaughter and other kinds of things, but a wrongful death suit. And the judge in that case, Don Kessler, said, okay, I need to understand this a little bit more. And he said, I need to understand history. I need to understand how we have understood embryos in history. And because his niece is Sandy Mitchell, who's head of the HPS program at Pittsburgh, and a friend of mine, she said, talk to Jane. So he talked to me, and I served as an informal expert advisor to the court. He could have hired me, but I said, I don't want to do that. Let's just do it informally. So historically, I could show how embryos have been understood. And he ended up with a ruling based on the historical work and with many footnotes to the historical work. He ended up concluding an embryo is not a person, which has become an important precedent case for others. An embryo is not a person. These early stages and this pre-implantation stage in particular is not a person. So those people who claim life begins at conception and personhood begins at the moment of fertilization are at odds with Judge Kessler's ruling. So I found that extremely interesting, that history actually mattered, and that mattered in a rather important way. And I think Carolina's going to say a little bit more about perspective on that case, which was at the Arizona level and did not go beyond because that settled the case. Now, I was just involved recently in a case in Texas. So Texas, Senate Bill 8. So state of Texas passed a law that was about the disposition of embryonic and fetal remains. So remains. The word remains already kind of suggests it's remains of something, not just material. So it's not embryonic and fetal material, it's remains, and they clearly want you to imagine remains of a person. So it's like human remains, only at the early stages. So they passed a bill that the embryonic and fetal remains in a medical facility had to be either buried or cremated. So in any medical facility, the law said, at any stage, if these were miscarried, so they come out of the mother, so even if it's just a natural miscarriage, if that happens in a medical facility, the medical facility is responsible for working with the mother, and that material, even an embryo, an early stage that you can't even see, had to be either buried or cremated. This was put in terms of dignity and respect for the person that the embryo or fetus is thought to be. So that sounds a little bit sensible at some level, but then Whole Women's Health, the medical group that provides the majority, actually, of women's health care in Texas, filed a suit, and the Lawyering Project, which is a nonprofit legal group, hired me and others as expert witnesses to fight this. So we became the plaintiffs, so against the legal case. And so I was going to say until last week that this case will be decided any day, but it got decided and we won. Okay, for now, it'll go on appeal after that. But okay, so the case, the plaintiffs say this is a bad law because it imposes a burden on the mothers, but most importantly, because it imposes and assumes a set of values about what we think this embryo and fetus is, a set of values that say that to give dignity or respect, it's necessary to bury or cremate, and that's the only thing we can do. So there was testimony from people saying, well, wait, I'm Muslim and I don't agree, or I'm Jewish and I don't think it's anything. I mean, the Jewish religion, I don't think it's anything until it's born, so no, I don't want to have that. But so again, they wanted a historian. So my expert witnessing, what is it called? Testimony, thank you. My expert testimony, witnessing sounded better, but yeah, anyway, my expert testimony was designed and did show that over time, there is a rich diversity of views about how this pre-embryo, embryo, fetus are understood and how they're valued. There is a rich diversity of views. So it's not just today people yelling at each other because they have different views. I'm pro-life, I'm pro-choice. It's that there's a rich diversity and range of views that are reasonable, and those are deeply held views for at least a couple of millennia. So it's not something we thought of yesterday. Well, back to Aristotle, and yes, anyway. So everything goes back to Aristotle. So that was my role. Now, that sounded dumb to me when they said, we want to hire you as a witness to come and say, hey, there's a diversity of views in America and even Texas about embryos. Because don't we all know that? Duh. But no, in the court, you need to have an expert say that. And so one of my books actually got admitted as a learned treatise, which means that any court can now use it and appeal to it to show that there's a diversity of views about embryos. Okay, fine, good. We're making a little progress here. And so the Judge Ezra has a very thoughtful, I think, ruling on the case, saying, no, this does, the case has been made. The plaintiffs are right that this law imposes a burden. And so, again, to me, this is extremely interesting how history. So it's sort of like Rick, my husband Rick, says, if you work on something for 20 or maybe now 40 years, really hard, you can be an overnight success and actually be useful someday. So I've been working on history of embryology for a really long time, and so now I'm delighted that it's actually useful someday. Okay, so those are two cases that I'm part of, and what it's showing is the way that our history and philosophy of science work can inform the public discussion, as well as illuminating the way that the public and scientific and legal and all these medical, all these different distinctions kind of intersect and confuse each other and cause us to really have to do careful work like we do in the Embryo Project, yes, to explain things. So we can say more, but we want to set up for questions about, okay, what are some of the changing conceptions? So I turn things over to Carolina.
Okay, thanks, Jane. I thought that was super interesting. I didn't even know all the stuff that you talked about. So we're all learning here. And today's question, Jane said we had big questions to talk about today, and we really do. The question that we're talking about today is, what does it mean to be human? And that sounds like a philosophy question. And while Jane may be able to go undercover as a philosopher, I I cannot. I'm not a philosopher. They use way too many big words for me. But philosophy isn't the only domain or field that talks about the nature of things. As we see, science determines what things are, whether it's an embryo or a fetus, a miscarriage or a stillbirth. And the court of law also talks about what things are. So when Congress passes statutes, they have to have definitions for what they're talking about. And court cases, discuss what is a criminal act, what is a valid contract, and what is a human. So we've learned about 2 modern cases, and I'll touch back to them at the end. But right now, I want to take you back in time to learn about some historical cases that shows we've been grappling with these problems for a long time, and at various points in history, we've actually come up with some answers. So the first thing I want to talk about, just briefly, is that in law, when we talk about what does it mean to be a human, it's actually quite different than when we just chat about what it means to be a human. So there's discussions about, does life begin at conception and stuff like that. That's not really the breaking point for what makes a human or not a human in law. So in legal terms, if you're a person, whether you have legal personhood, depends on whether you have standing in a courtroom. So standing just means that you can be on one side of the V in a court case. There's so-and-so, V so-and-so, okay? Both of those so-and-sos have standing. They can bring an action in a court of law, okay? So the first case in America that dealt with whether embryos or fetuses were people in a legal sense happened in 1884, and the case was called Dietrich v. Inhabitants of Northampton. So the facts of the case are, a pregnant woman was walking along the sidewalk. She came to a damaged bit of sidewalk, fell, and the fetus in her womb was injured, and she was injured as well. The fetus later died, and the woman brought the city, whose sidewalk it happened to be, to court to claim damages for her injuries and the injuries of her fetus. Now, there had been some other cases around this time that mused on whether embryos and fetuses were people, whether they could be legal entities. But this was the first case where the judge actually had to decide whether a fetus could be someone was standing in a courtroom. And the judge, who was Oliver Wendell Holmes, who's kind of a famous dude if you know him, he decided that no, the fetus could not be a person and have standing in a courtroom because at the time of injury, the fetus was part of the pregnant woman. They were one entity. And so the pregnant woman was the only person in the courtroom who could recover damages and have standing as a legal person. So the pregnant woman could recover damages for her own injuries, but not specifically the injuries of the fetus. That was really interesting. It seems kind of like bunk to me, but we'll come back to that in a second. And so there were other cases as we move into the 1900s that talk about whether embryos and fetuses were legal persons. A lot of the personal injury suits followed Dietrich's example. They said no, they couldn't. Embryos and fetuses couldn't recover damages because they're not people, because they're part of the pregnant woman. But there were cases in other legal areas that dealt with this question, whether an embryo or a fetus could be a bastard in terms of the Bastardy Act when they're still in the uterus, whether an embryo or fetus, while still in the uterus, could have an estate managed on their behalf, so whether they could be property owners, and whether they could act as a legal person in paternity cases, where people were trying to figure out, whose child is this? Is it a child? Does it deserve child support? I think they used a different term back then, but essentially it was child support. So nothing really changed in those cases. We had some interesting discussions until 1946. 1946 was another court case called Bombras v. Kotz. Bombras v. Kotz was a very similar case to Dietrich. A pregnant woman was injured, and so was the fetus. However, there were 2 very important differences. Okay, in Bombras, the fetus was much closer to being born, so it was much more gestationally developed. So it was farther down that land or that timeline into the fetus land. And also, the fetus was born alive and remained alive after birth. Okay, those are 2 important things that Bombras, the case, kind of deal with things differently. So the judge in that case was Judge McGuire, and he was like, well, at some point in pregnancy, doesn't the fetus become a separate entity from the pregnant woman? At some point, the fetus is born, but before then, I feel like there might be some place that the fetus becomes viable, and therefore a separate entity, and therefore a separate person from the pregnant woman. All right, so that was kind of an important use of the term viability. We see it playing around in the rest of the 20th century and even into the 21st century. It's a very important term that people like to hang their hats on in legal doctrines. However, bomb breasts wasn't decided based on viability or the science that Judge McGuire incorporated. Judge McGuire made a very legal argument. He said that if at some point the fetus becomes separate from the pregnant woman and we do not allow the fetus to recover damages from injuries done to it while it's in the womb, then we have an injury that we cannot legally address in our court system, and that is wrong. Every injury done to any entity in America should be able to be addressed in a courtroom. So that was his underlying reasoning for why a fetus deserved to be a person with standing in a courtroom. All right? So bomb breast was kind of a big deal. After that case, through the 40s and 50s, we had other personal injury suits using embryos and fetuses, but they mostly followed bomb breast precedent, and so those kind of fell by the wayside as an almost decided matter. Okay, so an embryo and a fetus had been given personhood as long as they were viable at the time of injury and they were born alive. All right, so as we move into the 50s and the 60s, especially as we get closer to the 70s, the discussion of embryos and fetuses in the courtroom changed. We moved from prenatal injuries and personal injury suits into abortion laws and laws or cases that challenged abortion laws. And so the discussion of personhood for embryos and fetuses also changed. It moved from whether they're people or humans to when they attain the rights of being a person or a human. All right? So as you guys can guess, the end of this story happens in 1973 with the case Roe v. Wade, which was the Supreme Court case that legalized abortion throughout America. And so that case had some hinky legal reasoning, I think. But essentially, that case gave the fetus or embryo the right at a certain point to live that superseded the pregnant woman's right to her body. So now we don't see whether the embryo is a fetus or not. We see whether the embryo or fetus's rights are more important than another person's rights and when they get those rights. The point of viability was mentioned. And in the cases following Roe, through the end of the 20th century, we still see that kind of discussion taking place. Legally, embryos and fetuses have a place as a kind of person with legal standing in specific instances, but now the disagreements or the battles in the courtrooms seem to be when we accord them their rights as a human and what kind of rights or respect are they given. So in Jane's Texas case, the law required that medical facilities treat embryos and fetuses as humans, even when they get ejected from the body through natural processes, if they're removed from the body during routine procedures like scraping of the uterus to get rid of some endometriosis growth. So that law really made people think of embryos and fetuses as more of a human than maybe some people wanted to. So the questions we want to get into it with you guys is, what counts as a human? When you think of a human being or when you think of embryos and fetuses, what criteria do you use to determine whether it's a human? So is it that they can do something? They can go to court? Does that make it a human? Is it about what they can feel or what sensations they have? So whether they have fetal heart tones or whether they feel pain, as some people like to bring up in conversation? Or is it a more emotional kind of thing? Like when you see in an ultrasound image that it looks like what you think a baby is, does that make it a human? So big questions, and we're really interested in all of your opinions on the nitty-gritty or the overviews. And we just really want to have a discussion about humanness and where science and the law come into it and how that all fits together in our messy society.
So as a reminder for discussion, we have to hold these microphones for the recording purposes, but you don't have to have a microphone to be heard. You just need to remember to speak up clearly. Okay, so we're opening for questions and discussions, and Jason's face had a question, and Haley has her hand up. So, Haley.
I just had a really small question, actually. Is there a law in Texas that states that adult humans are already like humans who have obviously been born and have lived have to be buried or cremated after death, or is that a separate thing that they were imposing on this population?
In Texas, as in most states, human remains have to be disposed of according to law, which involves cremation remains, or there are a few very weird exceptions. So this is according, as Carolina said, this is carrying the same protections or the same approach to embryos and fetuses, and saying that embryos and fetuses are no longer medical waste, which is how we have been treating them, but are now persons in effect. How do we want to do this? So
On that, is the difference between incineration and cremation just what you call the thing you're burning?
no,
They just incinerate
no, actually.
the fetal waste?
That's what they do now, in effect. So now the medical waste is treated carefully to protect public health interests, and it's collected in the, so lots of medical waste collected in the medical facility and then incinerated. Cremation means each one is treated separately, or it involves that each one is treated individually. You can't cremate you can't cremate a whole bunch of things all at once. So if you have an early stage embryo that, as Carolina said, maybe you accidentally, you didn't even know the woman was pregnant, endometriosis, scrape off the lining to help protect against that. You find, oh, there's a tiny embryo there. Now the facility has to take that and treat it separately and cremate it separately.
Individual incineration.
Yes. Now, the judge in his ruling pointed to an interesting hypothetical that he said was telling for him. The way the law is worded, it says in any medical facility. So he said, what if a pregnant woman goes to an ophthalmologist and she's sitting there in the ophthalmology chair, and then she has to, she feels uncomfortable and she has to go to the bathroom and then has a miscarriage, and then what? She can't flush the toilet. The doctor is now the ophthalmologist is now responsible for rushing and collecting that and taking it and calling up the funeral home. That's a little insane, he thought. And so that was a telling problem for him. Cindy, you?
Thanks.
Do you want to?
Historically, at least in early, say medieval, early modern Europe through, I guess, the beginning of the 20th century, many women typically understood or tried to not become attached to their fetus until quickening, right? So I'm wondering at what how much of an influence does that moment where you can first feel the fetus move inside the womb, what kind of influence does it have in these kind of decisions and in the court of law today, or even in people's opinions, really, do you know?
So yeah, quickening was a very big deal in court cases back in the early 1900s and before, because otherwise you didn't know anything about the pregnancy. So a lot of abortion laws said quickening was the deciding factor. Before quickening, you're okay. After quickening, you're not okay. The term quickening fell out of use in court cases as we became more scientifically advanced, then we could track things more easily. But yeah, quickening was really important for cases, and I think for people too. If you didn't know you were pregnant until you felt the kicking or the movement, then it didn't matter what was in your uterus. Yeah.
Catholic law, there's the term ensoulment, which is used more commonly as well, which went along with quickening at it's thought to be at about 40 days. So after about that 8 to 10 week period, actually. Yeah. Do you want to call in people?
Sure.
Yeah, this kind of follows on her question, and is sort of a corollary view of this. I've heard the term pregnant woman, and I've heard the term mother. And I want to know, at what point on that chart does a woman become a mother?
When the baby is born.
Is that legal?
No.
Okay, because we talk about, we throw this term
Right.
biologically, we throw it around
Right.
legally, and we talk about, abortion to save the life of the mother. And again, these are all kind of vague and hand-wavy, but I just wondered whether anybody had tried to pin that down.
Yes, people have tried to pin that down, and in legal discussions. So there's the what's going on in biological, what's going on in medical, and what's going on in legal discussions and other social discussions, and it's very sloppy. But the term mother gets injected in various courts at lower levels cases. As it moves up, the judges especially tend to be more careful. Jason?
So I want to ask almost the exact opposite question. On the timeline there, you've got 5 to 14 days at sort of the last point, 14 days, last point at which implantation takes place. But I'm going to ask about embryos that aren't intended to be implanted in the first place. So embryos that are, say, created specifically for or otherwise used for research purposes. Do any, yeah, exactly in that period. Are there any interesting court cases that focus on the so-called 14-day rule or on the status of the embryo when it's not meant to be part of a reproductive project?
In the U.S., not that I know of. In other, as you know, in your work, in the U.K., Australia, other British Empire, former British Empire countries, Commonwealth countries, there have been such cases. But in the U.S., there are some cases. It's more in law than in actual cases that I've seen it. But in law, there is reference to the pre-embryo and making the distinction that in the IVF clinic, what you always have is a pre-embryo, and therefore that all the laws and things that hold for embryos don't yet hold. So there is discussion along those lines. The Texas law about the disposition of, or the throwing away, disposal, they use the word disposition, but that didn't sound right to me. Anyway, disposal of embryonic and fetal remains specifically excludes in IVF clinics. But it's silent if there were a way to find a 3-day embryo floating around inside the mother, it's silent on whether it would have to be treated if it's in the medical facility. But if it's explicitly an IVF and has not been implanted on purpose, then it is not counted. And the CDC talks about, they try to make some distinctions and talk about a moment of recognized pregnancy, and before that there's a different status, different legal and biological status before it's a recognized or established pregnancy is the most recent word they seem to be using. So yeah, messy.
Let's go to Ben and Brittany.
Well, I was just going to say on that point, surely the Sibelius is the one instance I know of in which that question came up, and there was this question of standing. So I don't know whether that's sort of whether you guys want to comment on that or not. Because that question of, it speaks to what Carolina was talking about before, was a question whether who can have standing.
Yeah, so over the summer I went through over 1,000 court cases. Unfortunately, my terms of exclusion ended at 1973. So the interesting bits about IVF embryos and whether embryos outside the body have standing occur after 1973 mostly. So I'm interested in looking at that as like a side project, but I don't know that case well enough to comment.
So the case that Ben mentioned arose because of stem cell research and question about whether, in particular, whether some researchers had standing to sue on the grounds that they were being disadvantaged because they did adult stem cell research and this human embryonic stem cell research was sucking away the money, and they didn't think that was appropriate. That was part of the stimulus for the case. And Judge Lambert, who ruled in that case, did discuss some of the issues that we're talking about, but yet that was overturned. So
Frozen embryos would be the subject of research were
Right.
made as a part
right,
in that original suit,
right,
and the court did not recognize that as having standing.
right, exactly. So there's still some open questions there. Britt?
So I kind of want to take some of the society and the policy side and kind of more into the ethics of it. So like we kind of know today kind of what some of the backlash of like Roe v. Wade is and how religious ideologies kind of play into this public opinion. I'm kind of curious because you talked about some other major cases, I think in 1886 and then in 1946, and how were religious ethical arguments made maybe, and how did they affect public opinion both during these cases and then kind of after?
Yeah, so that's a really great question and a big role that we see today in discussions of embryos and fetuses. What's most interesting to me is that prior to the 1950s, religion wasn't really involved. Like the church wasn't super into this, we see today such, I'm trying to think of a word that's not rude, but such enthusiastic discourse from the church and religious people today. That really wasn't the case back in the 1800s and the early 1900s. It was a really strictly legal matter when I did a review of New York Times articles that mentioned embryos, and embryos were treated really neutrally, almost ascetically. When you get into the 1950s and the 1960s, some of this can be traced to the merging of the social right and the financial right, and so a different political party kind of got made. But religious people really got involved in the middle of the 20th century, and that's when you see a lot of the discourse shift from whether they're a person to what rights of the person, like the right to life, didn't show up until that time period. So before then, it was more biology focused and less person focused.
Related to that, but not exactly answering your question, they're almost little packages, like little black boxes or something that get sealed up that say, this is the religious view, and if you're religious, you're supposed to think X. I got, on the Texas case, I got applause twice in my testimony. The first was when the guy for the state of Texas, who wasn't as much of a jerk as he could have been, but he occasionally got a little jerkish, and he really pushed me, and he said, so are you pro-choice or pro-life? Which really shouldn't have been relevant, but I said, neither one. I reject that dichotomy. I am pro-choices, and that we should all have choices. And he said, yeah, but are you religious or not? And I said, that's not a relevant question, and I got applause. So, but the point is that people assume, they make a lot of assumptions about what the views are. Second time I got applause, he asked me, because he knew from the deposition that I had said that I donated to Planned Parenthood. And he said, do you donate to Planned Parenthood? And I said, yes. And then he sort of looked at me and said, that tells us a lot, which he's not supposed to say really, but it was a judge trial without a jury, so he was saying things like that. And I said, yes, it tells us that Planned Parenthood was started in the state of Arizona, and that, as we know, it was started by Republican women and Catholic priests.
And Barry Goldwater.
Because there was a feel that it was important to help women who were having more children than they wanted. So it was important to give them choice.
So they could be fiscally responsible.
Yeah, so that got applause as well, and people coming up to me and saying, wait, what? Planned Parenthood goes along, religious people can support Planned Parenthood? I'm religious. Can I support Planned Parenthood? Is it really okay? So point is, you say religious, I mean, that's taken on this kind of like boxy meaning that people don't think about really what they're saying. And religious what? I mean, the different religions. That's another point. There's a variety of religious views. Anyway, Rick, I think, had a hand up.
Does Texas make provision that the fetus can inherit?
No, there are no states yet. I believe that there are no states where a law has been passed and upheld that gives right to inherit to the fetus. There's been discussions, but they haven't been upheld, right?
Yeah, in the cases I've looked at, which were indeed way back when, there were discussions of estate management, and in the name of the fetus was bandied about, but usually there was like an actual adult who was like the executor of the will or the guardian of the estate. So there were some where the fetus was nominally given the right to inherit, but there were some conditions involving that. I don't know about Texas. I doubt it.
There have been attempts. There was the national personhood movement, which Jason may know more about than I do, but the personhood movement, which tried to get rights for the fetus, and there were ballot initiatives in 3 different states: Colorado, Mississippi, Georgia, Arkansas, forgot. Anyway, where they were all roundly rejected, but there were attempts at that level. And then Paul Ryan and a number of others in Congress tried to get a personhood amendment that would give inheritance and other legal rights to fetuses, but that didn't get out of committee. So there have been attempts to make such rulings, and in the state of Texas there were attempts, but they never have become law, or the one thing that was kind of that way that became a law was then struck down. So yes, they're
The issue of tax deductions and
Right.
so on.
right.
Firearms.
Who?
And fetal speech.
Yeah, in Texas, that's right. Firearms,
There's a 9-month wait period for firearms.
firearms in utero. Right,
Might inherit firearms.
right.
There have also been interesting cases with workers' compensation. If a pregnant woman was injured on the job, is the fetus entitled to workers' compensation? That was an interesting case I ran into. Well, they're not as well versed as you, Rick.
Before labor even started.
So Carolina's review of all these different cases is quite illuminating. You've been looking more at high-level cases, but we find there's such a patchwork of cases in this country. They're the federal cases and the Supreme Court cases, which hold for everything, but there's so many state cases, and some states have a Supreme Court which is parallel to the U.S. Supreme Court, but others have different court structures. And so there are a lot of different laws that are quite contradictory, as Rick points out. It's not just both sides of a mouth, but many sides, many mouths. Yeah. So in the U.S., the failure to pass any kind of clear federal regulation or legislation about what we mean by these various things has led to this patchwork at the state level. And so a lot of people are now worried, a lot of liberals are worried that the appointment of Kavanaugh to the Supreme Court will tip things and that we'll lose Roe v. Wade. But there are a number of experts who are saying Roe v. Wade is almost irrelevant. I mean, most of the abortions that are done now are done in the first 8 to 10 weeks, and they're done by medication, so they're not as problematic. But so, you know, the situation is changing, but what's happening is the states are rushing in to fill up that space and filling it up in a variety of different ways.
Is anyone making a states' rights case for this now, or is it just the vacuum when they fill it?
States de facto have the right. I think Liz and then Rainey.
On the subject of the patchwork of state laws, I'm curious to hear more about the future of abortion legislation in the U.S.
Oh, you're in charge of future. You're younger than I am.
So my specific question is does the status of personhood play into determinations of whether, or because I know that some states are passing laws prohibiting abortions on the basis of sex or race or genetic abnormality. So does this question of what makes a person with legal status play into that conversation? And like what will those laws be adjudicated on when they inevitably get litigated?
Yeah, so there's a lot of, as Jane says, I'm in charge of the future. So in the future I see, there's a couple of different threads of kinds of laws that are targeted at reducing the number of abortions provided. Some of them have to do with not the embryos or the fetuses at all, but have put heavy restrictions on the facilities themselves, how wide the hallways have to be, whether they're an ambulatory surgical center, which means you have to have a lot of expensive equipment, and whether you have to have permissions at a hospital. So those are ones that are targeted at the abortion providers, and they're unfortunately largely successful because the renovations are expensive and it's hard for people to find the new space or things like that. But there's also, where I think most of your question lies, is how are we deciding if we think fetuses and embryos are people at a certain point? How do we decide when abortion is okay and not okay? Is that kind of what you're asking?
Yeah, and with the decision criteria, when it's not just a matter of how far into the pregnancy, when there's these other like sort of orthogonal ways of adjudicating that.
Yeah, I haven't seen any good or bad cases where it's not about the time of or the gestational period. Mostly people have been trying to move the gestational period up. So there was the 6-week abortion ban that was in Indiana, I want to say, and stuff like that. But I think it's really interesting to consider, you know, what we count as a person and what kind of person gets to count and what criteria we use to describe that. I don't know what that's going to look like.
So most of the discussion that I know about surrounding well, actually, you know as much about this probably as we do, but surrounding selection for sex or for particular characters, that kind of characteristics, that kind of thing. Most of that is happening in individual clinics making decisions about what their protocols will be, or groups like the American Society for Reproductive Medicine making guidelines that then get followed by the groups that sign on. And so it's less at the regulatory legal level and more at the kind of volunteer level. And I think that it's likely that we will see cases, but I haven't seen any yet.
So most of the places where that's an issue, places like China or places that have a high preference for what kind of child people have, that's where most of those laws or regulations, thank you, come in. So in China, I know there's been some action to reduce the number of abortions of female embryos and fetuses. And a student did some research on this, and it was clear that there are only regulations like that where the society as a whole had a preference for what kind of babies were being born. So if there was a male preference or a female preference or other kinds of preferences, how they looked, stuff like that.
There are a bunch of states in the U.S. that have passed
Really?
bans on selective sex abortion.
Yes.
And so I see that. Like my take on that is it's one of many ways to whittle down when abortions are possible.
There are a number of states that have passed laws, and as far as I know, and according to something that I read recently that was as of a couple of years ago at least, there had not been court trials of any of those, so that those laws have not been upheld or overturned in any cases I could find. Yeah.
So I guess I was just curious,
Yeah.
how are they going to be tested?
Yeah.
I
Well,
think you'd have to have the reason for why they would be wrong, which can be tricky sometimes because America is such a freedom to choose place. So I think that you'd have to have a really compelling reason to tell people why they can or cannot abort a certain fetus out of preference.
and they're not clear precedents in that. There are wrongful birth and wrongful death cases of various relevant sorts, but none of them is telling, I think, on what would be the case, what we could expect. Rini?
So you guys talked earlier a little bit about how language and rhetoric in legal documents and like in societal discourse really influences how people receive this topic. Kind of talked about like how miscarriage, how people hear that. Are there any other words like that, or like how effective is that? And is that deliberate? Do lawmakers deliberately choose words to try to sway people certain ways?
Duh, yeah.
Yeah, I think they
Good
probably
point.
do. But interestingly, in a lot of the cases that I looked at, even some high-level ones, you see a lot of colloquial terms. Like it's not always embryo and fetus. There's a lot of unborn child or baby and things like that. So people aren't, as Ann Kinzig pointed out to me a while ago, people aren't clear with their language. Oftentimes they're sloppy. And so the sloppiness can have unintended or possibly intended effects. And so the fact that unborn child is showing up in a case about whether a fetus is a person or not, like the use of child already kind of predisposes one reading the case to think that maybe the judge thought the fetus was a person. I mean,
So it's not just the word, but it's context in that case. Or I was actually working as a science advisor in Congress when the partial birth abortion ban came along. And so I was in the staff, among staffers as they talked about what term to use. And so some people said, oh, that's kind of gross or that's too extreme. And then others said, no, go for it. That'll really work. We can really get somewhere with partial birth abortion. That sounds like a terrible thing. And so very strategic, very purposeful choice of words. In the Texas case, the use of the word remains was clearly extremely intentional because you can look at the very first drafts and they called it medical material, and then that gets crossed out and remains gets put in there. And it would be great dissertation topic. Anybody who hasn't figured yours out yet? Yeah. or 10 or 15 dissertation topics. Do we have time for like one or two more?
One or two more, I think you have your hand up.
How are insurance companies handling this? Have you seen any cases in which insurance is covering abortion, or how do they handle miscarriage?
Yeah, I actually have cases with insurance claim as the tag. There's a lot of questions of whether if a fetus dies in the uterus, whether it's miscarried or stillborn, whether someone can recover like a life insurance policy or whether the insurance company like owes them something. And it's kind of been across the board. They're very specific cases, not like a huge trend of them, but so it's decided based on the particular instances of the case. But there's a lot of interesting things about, or the interesting cross-section between insurance and medical care and then legal definitions, because they all have to do with what is a person, but for different purposes. Like an insurance company maybe wants to get rid of the personness of the thing so they can't be a life insurance policy or something like that. I was going to say something else very interesting. Oh, I've forgotten. I might remember.
But yes, there's a lot.
Yeah.
It's really messy also. And some states have regulations covering what insurance companies have to do and others don't. One last.
Okay.
Wait, she had one. Sorry.
Yeah.
Oh, somebody. Oh, who are you pointing to?
I think yours was
Yeah.
first.
Okay.
Good.
I
you, sorry.
guess my question was, does the ability to tell like the sex of a fetus factor into whether or not a fetus is considered a human or not? Like I don't know like how far along in the time period you can tell the sex of a fetus. So does that factor in at all?
If you have it if you have it in the dish, so to speak, in IVF, you can tell right at the beginning.
Yeah, and there's
So
also
no, that's not really relevant factor.
Okay.
Yeah, but there's other ways to do it. You can test the pregnant woman's blood to see, because there's fetal cells. Yeah, fetal cells circulate through the pregnant woman's body during pregnancy. So if you extract blood from the pregnant woman's arm, you can find the fetal cells. And if it's an XY, you know it's a boy because it's not the mother's blood.
Which is why every woman who's had a baby becomes a chimera technically and has the baby's cells flowing through her.
Supposedly they're very useful for healing. Anyway.
Okay.
No. There were studies about fetal cells function as stem cells and can assist with women later in life recovering quickly or having better adaptability. It's science, Jane. I'm a scientist.
Do we have one last?
Yeah.
Ben?
So I'm wondering, having been through these experiences, Jane, having thought about this quite a lot, what do you think about the courts as the sort of de facto arena where these questions get asked? Because the notion, standing is a pretty attenuated construction of an interest-holding entity, and it's also a highly flexible one. So, maybe that the race and gender selection comes in through protected classes, right? That might be the basis for standing. Super PACs have standing, right? It's been, I don't know how many decades since Christopher Stone's seminal piece that asked, do trees have standing?
4 decades.
4 decades, okay, so creative work, and since then there's been a lot of creative work to get trees standing or other such entities, which has been achieved in certain jurisdictions. Anyway, so my question is, given the fact that there are these quite strict constraints on the kinds of questions that you can ask in this arena and the way it gets deliberated, I wonder what you think about the virtues or deficiencies of making the courts the primary arena in this country where these questions have been asked.
It's whether it's the primary or certainly the courts are a major place where these questions play out. I think from my experience, so I thought this a priori and I thought this much more after having watched this case go forward. One of the worst things about the way the court discussion played out in this case, state of Texas brought in 3 bioethicists, and there's you bioethics guys know this, there's a stable of bioethicists for hire. And so these guys were all ones who have testified whole lots of places. They were terrible, they were unclear, there was a great one, Thomas Cunningham was on our side, but the people on the other side, you can look it up, but they all had a canned spiel, and they didn't care what anybody else said, and that's a problem. That's a problem if that's what we're going to be bringing into the court. So it's really important that the good guys that in fact different voices and different considerations get brought into the court. So it's a problem if it's these canned sort of over and over same arguments by same people that are excluding a lot of factors that are relevant.
I can tell you what the courts think about it. The judges don't like it. They think that this is the matters of what an embryo or a fetus is and how they should be treated is a matter for the legislature. In like dozens of my court cases, they write a note at the end and say, while we've decided this case, we really think this is a matter for the legislature. So we're going to put this like little patch on this problem, and we're not going to, create a whole new doctrine about how we should treat these things, because that's really for the legislature, and they should be the ones to decide how we're going to treat these things in general. So there's been a really piecemeal way that we've gotten to where we are. And so it leads to a lot of slippage and a lot of holes and a lot of strange contradictions.
Great point. When I was doing education programs for the Federal Judicial Center and talking to groups of federal judges, that came up all the time. Wait, we're not in the position to decide this. Wait, we don't want to decide this. We don't want to be legislating from the bench. And that was said by people who were appointed by Nixon and Reagan and Carter and Clinton. I mean, across the spectrum politically, they did not want to be the ones. Now, this guy in Texas, the Texas case, Judge Ezra started out and said, "This is going to be a landmark case. It will be precedent-setting for other cases," and he was probably right, but he sort of enjoyed that. Anyway, it's 1:00. We should end there, and thank you everybody for coming.
Thank you so much.